Hello, this is Matt on the Moon Family Said Dan channel. A major bank is going to allow its clients to purchase XRP along with a couple other cryptocurrencies. And this is all happening, of course, despite the SEC v. Ripple case still playing out, because, as I've stated and many others have for the last 2+ years, the rest of the world in the end will not give a damn what the US does to destroy XRP in the United States and broader crypto markets. Whatever happens in the United States, it's not going to impact the adoption of decentralized cryptocurrencies like XRP. And so that's why, I still admit that there's tremendous risk holding XRP, in particular for people in the United States, because of the SEC specifically. Look, I'm more afraid of what the SEC is doing in regards to my financial well-being compared to any sort of volatility in crypto. I'm way more concerned about the SEC. But despite that, I continue to hold and understand that this could be a multi-year process, especially if this actually goes to the Supreme Court, which I don't think will happen, but it could. But if it does, I'm going to sit here and continue to hold unless they somehow pry my private keys out of my head. If the government can do that, okay, then I guess you got my XRP. But outside of that, I'm just going to wait for this damn thing to play out, because when you come out on the other side, not only will there be, I think anyway, a dramatic jump in terms of adoption and price appreciation as a result of that type of clarity, all of the real world adoption, which I think is going to play a larger role, especially in a mature market in terms of where price lands, well, that's all unfolding everywhere else on the planet. It's not like adoption of XRP is stopping because there's a bunch of asshat pricks in the United States and at the SEC trying to stop this. So I'm going to share with you the news of what the bank is doing, because you can expect to see more and more of this as the years pass. And then there's also an update for you from, it's on the topic of what's happening with Coinbase, because as you know that the SEC is about to sue the ever-loving hell out of Coinbase. The Wells notice was sent out, which is a warning, hey, we're about to sue you effectively. In a nutshell, that's what it is. And as far as I'm concerned, it's a formality because Gensler's got the votes. It's going to happen. I feel like that's a virtual certainty. I could be wrong, but that's the way I'm looking at it. And I've got comments from 3 attorneys within the XRP community on this topic: Attorney Bill Morgan, Attorney Jeremy Hogan, and Attorney John Deaton. So we're just going to have a blasty blast here. But before going further, I do want to be clear. I do not have a legal or financial background of any kind. I'm not offering legal or financial advice. And you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Now, at the outset, when I said a major bank is going to be allowing its customers to purchase XRP, you didn't think I meant in the United States, right? Because obviously there's the SEC lawsuit that would stop any bank from even considering such a thing. Now, as a result, I'm probably going to butcher this bank's name because it's foreign to me, but I'll do my best here. It looks to me like Raiffeisen? Nailed it. Bank to offer clients Bitcoin, XRP, and Shiba Inu investments. We'll just call it RLB because that seems to be the ticker symbol. A regional bank located in Austria and a member of the Raiffeisen banking group is planning to make history as the first traditional bank within the EU to provide its customers the opportunity to invest in digital currencies such as Bitcoin, XRP, and Shiba Inu, among others. And by the way, the only thing I kind of don't like about this development is that XRP is in any capacity being lumped in with Shiba Inu. Oh, I don't know. We'll see what happens. I don't know. What if some of the meme coins actually persist? Like, what if 30 years from now, Doge is actually somehow still a thing? I don't know, man. I don't know for sure. It just seems silly right now in 2023, but who knows? Weird stuff happens, right? I mean, who would have thought 14 years ago that magic internet money would still be around in any capacity? So who? Anyway, the regional bank plans to offer its clients the opportunity to invest in Bitcoin, Shiba Inu, and XRP by integrating Bitpanda Technology Solutions, which provides institutions with an investment as a service solution. Bitpanda currently supports 2,500 plus assets across 5 asset classes, including crypto, stocks, ETFs, metals, and commodities. Bitpanda announced the planned partnership in a recent blog release. In an official statement, RLB emphasized the significance of the partnership and revealed that it had signed a letter of intent. The bank stated that it is presently scrutinizing the feasibility and particulars of the collaboration with Bitpanda, and the assessment is expected to conclude by the end of this year. And so, again, XRP, just because of what is happening in the United States, isn't being shunned elsewhere in the planet, with rare exception, by the way, which is, with that part's positive. RLB's clients include over 270,000 distinguished corporations, institutions, and individuals in Lower Austria and Vienna. As a result, this development will greatly boost Shiba Inu and XRP, as it could bolster their adoption rates and significantly increase demand. Yeah, that's right. Welcome to legacy finance, crypto. And not that this is the first instance of something like of legacy finance adopting any sort of notable way crypto. I mean, even just, PayPal just jumping into crypto, BlackRock, just a couple off the top of my head. But the point is, you're going to reach this point in the future where, the lines will be blurred between what is a crypto exchange and what is a traditional finance exchange. Because I won't be surprised in the least if in at least certain parts of the world, you're seeing stocks traded side by cryptocurrencies in the future. Why wouldn't you want to have it under one house? And then it's just like, what type of exchange are you? You're just an exchange at that point, right? And then with the tokenization of everything anyway, that also blurs the line. And like if you tokenize all stocks, well, okay, I mean, it's still stocks. It's a representation of a stock. I'm just saying it starts to blur the lines a little bit. And then they also state here, RLB integrating digital currencies like Bitcoin, SHIB, and XRP into its investment offerings will likely provide its clients with increased flexibility and diversification opportunities in their investment portfolios. This move indicates a growing trend among financial institutions now beginning to incorporate digital assets into their offerings. And I remember talking about that concept, half a decade ago, and it sounded way more crazy back then, but here we are. It's not crazy at all. It never was. And it's just going to keep going that direction, which is why I said at the outset of the video, even if we have to wait years and years in the United States for clarity and go to the Supreme Court, I'm optimistic justice will be done and the adoption will be occurring in the background. And that in conjunction with positive news, even if it were years from now surrounding XRP, which again, I'm not saying it's going to take that long. I'm just worst case scenario. If that actually happened, bam, like I still want the exposure. I personally going to continue to hold. Now, on the Coinbase front, they've become very familiar with what you might want to call the Ripple treatment. How the SEC has treated Ripple over the last couple of years here. And it's been interesting seeing, Brian Armstrong, the founder and CEO of publicly traded exchange Coinbase, discovering all the stuff that we've been sharing in the XRP community for a couple years. The Twitter sleuths, as Ripple CEO Brad Garlinghouse put it, look at finding all sorts of documents and videos, things that would absolutely destroy the SEC's argument. For example, there's and this is just highlighting hypocrisy in this one example here, but there's a video that's been circulating within the XRP community for about 2 years at this point. And it's Gary Gensler. And he's saying that probably about, this is when he's teaching at MIT, mind you, he's saying that probably about 3/4 of cryptocurrencies are actually commodities. So now fast forward a few years and he says that everything but Bitcoin is a security. Which one of those Garys is telling the truth? I want to see that first Gary debate the second Gary, because one of them's a lying liar. And I think I know which one it is. And so that video has been circulating again recently. And Brian Armstrong saw it and he retweeted it from somebody and he wrote, wow. And then it's like, we in the XRP community, we look at that, we just like, how can you not just kind of do a audible sigh and face palm and the eye roll and the whole bit? How could you not do that, knowing that they were silent for most of the last couple years? I appreciate the amicus brief they wrote finally at the end, but where was the rest of the public outcry? They just, booted XRP to the curb. They were silent, and now they're sharing the same video clips that the entirety of the XRP community has been sharing. And he's like, oh my God, this is outrageous. Now it's outrageous? Mr. Clean, where were you a couple years ago? I don't understand. How I don't get it. And so that's why I've said many times, it may just be the case that back then they really were just linguini spine sons of bitches, and now they're just like, well, we have no choice, and they're growing something of a backbone. But it's just frustrating to see. You can understand that's frustrating. Well, of course I can. I mean, we all get it. We've all been in the trenches the last couple of years, right? So here is Coinbase's website with the headline, Coinbase Responds to the SEC's Wells Notice. Last month, we shared that we received a vague and broad Wells Notice from the SEC. Today, we're sharing our response to the SEC. We provided a written and video submission to the SEC, and we discussed those submissions with the SEC a few days ago. Coinbase is in the same Coinbase is the same company that we were when the SEC allowed us to become public 2 years ago after detailed discussions with us about the very aspects of our business that are now the subject of the Wells notice. We didn't list securities then, and we still don't. We'd like to in the future, but the SEC has still not complied with the law by providing companies like Coinbase with a way to register to be able to do that. We do not relish litigation against the SEC, but we will vigorously defend ourselves and stand up for the rule of law for everyone. In the meantime, the financial system still needs updating, so we'll continue building. We will also continue to ask Congress for legislation and the SEC for rulemaking so that regulatory clarity isn't left to the courts. And then in this CoinDesk article covering this, they shared a snippet of an additional thing that Coinbase stated, which reads as follows. The threat of imminent litigation appears to be intended to pressure Coinbase to accept demands that the Commission simply does not have the authority to order. Namely, that Coinbase, number one, agree that virtually all digital assets listed on Coinbase's platform are securities, and two, overhaul its entire business model to register as an NSE, National Securities Exchange, and clearing agency, potentially requiring Coinbase to jettison its entire customer-facing business and overhaul its public company governance structure to conform to limits on concentrated voting control of NSEs and clearing agencies, end quote. What does this sound like here? A bullying tactic? Accept the demands of the SEC? Authority they don't have? And again, I appreciate the amicus brief this past, I guess it was November when it was filed, but where the hell was this argument when it was just Ripple pushing back and the XRP community pushing back? It's just frustrating sometimes. And then they wrote here, neither of those objectives is supported by the law or within the bounds of the Commission's authority. Yeah, I know, it's outside of law, and the SEC is making a jurisdictional land grab. Like, that's exactly what this is. And Coinbase is correct on this. So I'll continue to support them and rally around them, but every now and then I'm just going to bitch about it because I'm annoyed. Come on, can you blame me? Come on. I think a lot of us feel the same. And so in response to all of this news breaking, attorney Bill Morgan of the XRP community wrote, best of luck with the response. While you are at it, why not share with Ripple's attorneys the views you shared with the SEC about asset listing in XRP? Now, that's a good point. I would love for that to take place. I don't know. Technically, it could have behind the scenes, and we just don't know. I kind of doubt it, though. But I guess it was, if memory serves, the beginning part of 2019, when Coinbase met with the SEC. They said, here's why we think XRP is not a security, and we intend to list it unless you give us a reason not to. And then the SEC just didn't say anything to the negative, and then it got listed. Okay, so what was the analysis Coinbase used at that time? Have you shared that with Ripple? Good thought from attorney Morgan. Then there was also this. In response to the news from Coinbase, attorney Jeremy Hogan wrote, there's just no way to reconcile allowing Coinbase to sell shares of stock to the public and then turn around 2 years later and say the sales are all unlawful. That's not investor protection. It's a regulatory rug pull. Now, that is spot on. I don't know. Assuming this goes to trial, and, I understand there can be summary judgment, but assuming it gets to that phase, and I think, as far as I'm concerned, it is, because, like I said, the Wells notice, I think it's just a formality. I don't know how you can get a judge who is unbiased, who looks at this and isn't just bamboozled by all, what the hell are you talking about? What's this horsepuck malarkey, son? Like, what is it? You, the SEC, allowed this company to go public under this specific business model, which is still implemented. There's been only minimal changes since then. And now it's all wrong and bad. What the hell? That's your fault, SEC. Oh my God. If it were true, it's not true. It's not all bad and illegal. But it would be the SEC's fault. So what the hell are they doing here? This is going to look, to any unbiased judge, completely disingenuous. XRP community member NFT Bounty Hunter responded and wrote, I bought Coinbase during the initial public offering because it was deemed as safe by the SEC. Shouldn't I be able to sue the SEC for damaging my investment through their back and forth regulation? Attorney Hogan responded and wrote, yes, if the SEC was a company, these actions are negligent at best and intentional at worst, giving rise to punitive damages. So, special protection since it's the government. Yay. But but the good news is, even though they do have this special protection, when it comes to whether or not they will win or lose, that won't play a role. It really shouldn't. Like I'm telling you, no judicial system is perfect, but here in the United States, especially for something like this, it's not commonplace to have some sort of like corrupt judge. This isn't like a third world country and banana republic stuff. Like, that's not what's happening here. You're not likely to have some sort of corrupt judge that's just going to be like, yeah, I got you, Kim Jong-un, I got your back. No, that's not how things work here. So that's why, in a general sense, I'm still optimistic here. Then we also have this. There's a tweet from XRP community member Mr. Huber, and he tweeted out the following: "Hey, John Deaton, Ripple was not only in 2022, but already a client of Sullivan and Cromwell before Clayton ever filed the SEC lawsuit. Shouldn't Clayton have abstained in this case? Did Hester Peirce vote for this? Is that why Clayton said it was not his decision to file such cases?" And then Attorney Deaton responded, and he said, "Clayton should not have voted because his law firm represented Consensus and brokered the purchase of Quorum between Consensus and JP Morgan, which was pushing JPM Coin, a direct competitor to Ripple and XRP, as you can see. But conflicts of interest don't get in the way at the SEC." Now you have, in response to that, an attorney named Mark Fagel, formerly with the SEC, by the way, disagreeing with Attorney Deaton. And Attorney Mark here says, "Sorry, but that's like 3 steps removed from any actual conflict of interest. The SEC was extremely rigid about conflicts during both during and after my tenure. You can always find some optics issue if you squint hard enough, but this is not a legal conflict." So look, I'm going to be as fair as possible here. You know that I admit I'm biased, obviously. But to be as fair as I possibly can, from a legal perspective, I don't know what the standard is because I'm not an attorney in terms of, what is too far removed. But I can tell you as just a regular everyday person observing this, I don't have to squint to see a conflict of interest here. To me, it just looks like a plain old everyday conflict of interest. To me, it looks like Attorney John Deaton is making an absolutely correct point. Again, from a legal perspective, I'm just being honest as possible here and saying, okay, I don't know. But on the surface, to me as a regular person, yeah, it sounds like Attorney Deaton's right. Now, Attorney Deaton responded with something rather interesting here, having to do with Hinman. He wrote, "Mark, if they were so stringent with conflicts, then I'm sure you're willing to bet the SEC Ethics Office screened Hinman's speech for conflicts and gave him their blessing, right? I'm sure you will agree that his speech was unusual considering specific tokens aren't ever discussed." See, and now that is a brilliant point, because there's been all sorts of conflicts of interest that have been uncovered for over 2+ years at this point. And so the one he's talking about here is the Ethereum free pass speech that Bill Hinman gave on June 14th of 2018. Now, the ethics office leading up to that made it very clear that Hinman couldn't have any sort of proper communication. I think, if memory serves, I think he wasn't even allowed to have a phone call with people at his former law firm. Yet still, he gave the speech. How could it possibly be the case that the SEC ethics office would have approved that when they're like, yeah, you can't even have a phone call? And now this, which would substantially benefit and did benefit ETH, and as a result, his firm, his prior firm at that point anyway. So what do you mean? Stringent, it doesn't look like it here. And attorney Mark Fagel, formerly with the SEC, responded and said, "I don't know the answer to this. The GC would review my speeches, but I don't know whether they'd get run by ethics. I would go to ethics if I had concerns about a conference/program sponsors, but I don't know about the specifics for that specific speech." Well, again, with Hinman, do you think that he ran it by ethics, the ethics office? I don't suppose that he did, because I don't think that the speech would have been allowed had he done that. So in terms of conflicts of interest and being 3 steps removed and nothing that just, it rings hollow to me. Again, I don't know the legal standard, but it just rings hollow to me. It just seems like nonsense. Just on the surface. That's all I'm saying here. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.